Hello and welcome to assetyogi.com. This is Mukul and in this video I will explain about sale deed. What it is, what are its essential elements and how to handle this legal document properly while buying or selling a property. I will also share few additional tips with you on property registration. So make sure that you watch till the end and not miss on these useful tips. Let's get started.
A sale deed is an important legal document that conveys the ownership from seller to the buyer. So to understand this better, let us first understand the complete process of sale of a property. Suppose you are interested in buying this property, then as a first step, you are going to negotiate the price with the seller. Then once you agree on the sale price, then you will pay advance to the seller, and generally advance is about 10% of the sale value. So whatever sale price you decide with the seller, you have to pay about 10% as advance to the seller, and after that you are going to sign an agreement to sell with the seller. Now this agreement to sell is not same as the sale deed, but it is an agreement to sell that property at a future date. So all the terms and conditions of sale will be written in this agreement, and the payment schedule will also be decided in this agreement to sell. Generally you will get 2 to 3 months to make the full payment. So this complete payment schedule will be mentioned in the agreement to sell, and there will be other terms and conditions of sale. For example, if the buyer defaults on the payment, then what are the kind of damages the buyer has to pay, or if the seller backs out from the deal, then what are the kind of damages the seller has to pay. So all these terms and conditions will be written in this agreement to sell, and once the buyer, that is you, make the complete full payment, then you execute the sale deed, which is the final document through which the ownership is transferred to buyer. And you have to pay the stamp duty for this sale deed, and this has to be registered in sub-registrar's office. Only then the sale deed is considered as legally valid, that the ownership has transferred from the seller to the buyer. So a sale deed helps establish the ownership right of the buyer, and it conveys the ownership from the seller to the buyer on payment of consideration. So this complete payment has to be made, only then the sale deed is considered valid. Once the sale deed is executed and registered, then all the rights of the seller are transferred to the buyer, such as the right to use the property, right to lease, right to mortgage the property, and right to sell. All these rights will be transferred from the seller to the buyer. A sale deed is sometimes referred to as conveyance deed also, but there is a slight difference because conveyance can happen in the form of other deeds also. For example, gift deed, a will, or even a lease title can be transferred with the help of a lease deed. Then mortgage deed is also a form of conveyance deed. So basically conveyance deed is a broad legal document which conveys any form of title from one person to the other person, and that right can be any form of right. It can be the right to use, right to lease, or right to mortgage. So gift deed, will, lease deed, mortgage deed are also types of conveyance deed, and sale deed is also a form of conveyance deed through which ownership right is transferred to another person. I hope this difference is clear to you. If you want to know more about conveyance deed and how it differs from sale deed, then I request you that you watch our other video on conveyance deed, where I have explained about it in great detail. Now let's see what are the essential elements of a sale deed. A sale deed contains details of both parties, that is the buyer and the seller. So details like name, age, father's name and address are recorded in the sale deed. Then the sale deed will also record the complete schedule of property, for example the location, complete address of property and the description of property. So in the description, the area of the plot or flat will be written, orientation of plot and the details of construction, etc. will be recorded. Then the complete payment details will be recorded in the sale deed, such as sale price that was agreed upon between the buyer and the seller, then the advance amount paid, then the dates and mode of payment with check numbers or online payment reference numbers. All these details will be recorded in the sale deed. Then the time of handing over of original property documents will be recorded in the sale deed when the seller is going to hand over the original documents to the buyer, and the time of handing over of possession will also be recorded in the sale deed. Then the seller also certifies in the sale deed that there are no encumbrances and liens on the property, meaning that there are no charges and liabilities on the property. For example, if there is a home loan on the property, then the seller has to clear that home loan first, only then he can execute the sale deed, and he has to clear all other dues, for example maintenance dues, water and electricity bills, then our residents welfare association dues, property taxes. So the seller has to clear all these dues before sale deed can be executed. Then there will be indemnity provisions for both parties. For example, if in case of any negligence or breach of contract from one party, the responsible party is liable to pay damages to the other party. Now let's see what are the precautions you should take before you execute the sale deed. First of all, you have to ensure that the property has clear title. So you should conduct a complete title search for at least last 30 to 40 years. And you have to ensure that all transactions in the past were legitimate and that there are no third party claims. So when you are buying a property, you should take complete chain of title documents from the seller, right from the first owner to the last owner, and you should exactly know how the property has changed hands over a period of time. If there have been any disputes in the past, then you should also have a copy of any favorable court judgment also. Then you have to ensure that there are no encumbrances and liens on the property. We have just discussed that. So if there are any pending dues of any home loan, property taxes, maintenance or utility bills, or any dues of the residents welfare association, then the seller has to clear all those dues before the sale deed can be executed. Then you should thoroughly check the contents of sale deed and check for any ambiguities in the sale deed. The sale deed should not be a conditional deed. So it should not contain clauses like subject to fulfillment of XYZ. You have to ensure that absolute and ownership is transferred from the seller to you. Now let's see what are the steps involved in the execution of a sale deed. As a first step, a lawyer will carefully prepare a draft sale deed which will be approved by both the seller and the buyer. Once the draft sale deed is approved, then stamp papers will be purchased by the lawyer or the legal expert, because stamp duty has to be necessarily paid in every state and it can range from 4 to 10% of sale value. So your legal expert or the lawyer will print the sale deed on these stamp papers. Then the sale deed will be signed and executed by both buyer and seller, including the thumbprints, and every page has to be signed by both buyer and seller. The sale deed has to be witnessed by at least 2 witnesses, ideally 1 witness from each side, from the buyer and seller side. These witnesses will record their names, signatures and addresses on the sale deed. Once the sale deed is signed and executed by both buyer and seller, then it has to be registered at sub-registrar's office, and the seller will present all original property documents in the sub-registrar's office, and after the registration he will hand over all the documents to the buyer. And during the registration process, all parties including buyer, seller, witnesses have to be present in sub-registrar's office. Only then the sale deed can be registered. In case the buyer cannot be present, then he can assign a power of attorney, and the power of attorney agent has to show that original power of attorney at sub-registrar's office. The sale deed has to be registered within 4 months from the date of execution, and generally the buyer pays for the stamp duty and registration charges. I hope that after watching this video you now have a fair understanding as to what is a sale deed, what are its essential elements, what kind of precautions you should take while executing a sale deed, and how to execute a sale deed.
Thanks for watching. If you have any real estate and finance related questions, please leave them below in the comments. We may make a whole video on that. Give a thumbs up to this video if you found it interesting, and subscribe to this channel so that you don't miss out on our latest informative videos just like this. Don't wait, please subscribe. You really don't want to miss out on our latest investing tips and tricks that we share every week. See you guys in next video.